The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your occasionally bi-weekly podcast on the federal courts of appeal. I'm your host, John Ross, joined today by IJ Senior Attorney Jeff Rose, as well as Adam Shelton, who is our new Judicial Engagement Fellow at IJ's Center for Judicial Engagement. Adam, welcome to the show. And could you please tell our listeners what is judicial engagement? And could you please be concise so that the old listeners don't get bored, and also thorough so that the new listeners understand?
Thanks, John. Yeah, judicial engagement is simply the idea that judges should actually judge in all constitutional law cases that come before them. Right now, there are a whole host of rights where if somebody asserts that their right is being violated, judges will just say, hey, I'm sure the government had a good reason for doing it. We're not going to ask them to provide us the real reason for doing it. And we're not even going to ask them to give us any actual evidence that what they're doing is necessary, but simply that they have a good reason and kind of you're out of luck.
Okay, let's kick things off in the Third Circuit. Jeff?
Alrighty. Our first case we're going to talk about is a Third Circuit decision called Thomas v. Deputy Superintendent, and it's about a prisoner, Thomas, in the Pennsylvania state prison system. And one day he had a visitor, and the visitor thought, you're kind of down, how about a peanut M&M? And so Thomas took the peanut M&M, took a swig of soda, and that's when his problem started. A guard thought that might be a little suspicious. It turns out that one way drug contraband gets into prison is they'll hide it in a little piece of balloon so that it in a little ball, mix it in with something like M&Ms, and then the prisoners will eat it in the visitor room. So the guard spirited Thomas away to something called a dry cell. And this is sort of a dystopian experience like straight out of Clockwork Orange, where you go into this cell, you are stripped naked, given a smock, handcuffed to a bed, a light is turned on you that never goes off, and you have no access to running water, and the room is completely sealed. And they watch you and watch what comes out of your body. And Thomas accepted laxatives, and so he had 12 bowel movements in 4 days, was never given an opportunity to wash his hands or do anything like that. He was also x-rayed. X-ray found nothing. And then he was reviewed by the sort of prison, committee about this, and they left him in there for 5 more days. So Thomas brings a federal lawsuit saying this constitutes cruel and unusual punishment. The prison officials say, well, even if that's true, we have qualified immunity.
And what does the Third Circuit say, Adam?
Third Circuit in that case said that they did not have qualified immunity in regards to the duration that he was kept in the cell. He was kept in there for 9 full days, 4 days after. For the first 4 days, he had the 12 bowel movements and he went through the x-ray. Then after that, they kept him in the cell for an additional 5 days for apparently no real reason, or at least no reason that they've yet provided.
And so that seems to indicate that there's something that he can't sue over.
Right. So the other thing that he can't sue over is the actual conditions. We also challenged the conditions itself. And the court said that there wasn't enough evidence to show that the people that he actually sued had any knowledge of the conditions or had any control over the conditions that he was in.
What's the difference between the conditions and the duration, Jeff?
You might have legitimate conditions. Like, in other words, maybe you're serving a legitimate penological interest for the first 2 or 3 days. Prisons are allowed to be harsh. They are allowed to be restrictive. They're allowed to be punitive. But if the penological interest disappears and you've kept someone under those conditions for too long, even otherwise legitimate conditions can become unconstitutional due to their duration. Conversely, you could have conditions that are very short in duration, but if they fall so profoundly and egregiously below civilized standards of decency, those conditions can be unconstitutional too.
And so what precisely did the court find was at least arguably uncivilized here?
Yeah, so the majority opinion said, look, the first 4 days, okay, we get it. We understand maybe there's a legitimate penological interest, but you, the prisoner, the prison, do not have evidence that there was a legitimate penological interest for the last 5 days. Like after this guy had been x-rayed, inspected, had 12 bowel movements, there's no contraband. What's the deal with the extra 5 days? The dissent would have gone further and said the conditions themselves are so awful that he should be allowed to sue on that. But the majority only reverse the summary judgment as to the duration.
And so describe the conditions. The dissent gets a little bit more into what the condition. I mean, you said he was chained to a bed, but what does that mean?
Right. So he's handcuffed to a bed frame in a smock. He can't stand up. He can't sleep because you can't roll over and your arm is stretched over your head. There's a light shining down on him at all times. He's Muslim, and so he didn't have the opportunity to cleanse himself before his daily religious obligation of prayer. You have to, you go to the bathroom in a bottle and in a bedpan for 9 days. And the dissent particularly gets into the idea also that sleep deprivation itself can be a form of cruel and unusual punishment. And so not letting someone sleep properly, shining a bright light on them 24 hours a day reduces you to a mental and physical condition that could constitute cruel and unusual punishment.
Adam, does this strike you as judicial engagement or judicial abdication, this decision?
Well, there's parts of it that strike me as both. So the majority's opinion saying that he could sue for the duration was quite a nice thing of judicial engagement. I think at one point the defendants in this case argued that we had a reason for doing it. We just didn't write it down. And we talked to the security officer. We just didn't note that we talked to him, and there's no actual evidence that we talked to him. But you should just kind of believe us. We're good officers. And the court kind of said, no, you were supposed to write a reason down in the first place that you kept him in there for past those original 4 days, and you didn't. So because you didn't follow procedures in the first place, we're not going to assume that you followed any other procedures that you were supposed to. However, I think it was a bit... The abdication part comes in as far as the conditions. The majority opinion didn't really talk about the conditions. They didn't really go in depth into it at all. They just kind of said, hey, we agree that they likely didn't know. And that was how they kind of did away with that part of the case.
Well, who didn't know that? Was he suing the prison officials or the prison guards?
He was suing the prison guards, from what I understand.
Jeff, how would the guards not know that he was in an uncomfortable position for 9 days?
Well, they did know. What the court was concerned about was whether or not the conditions were serious, objective deprivation for those first 4 days. And I think the court was just persuaded that you can dry cell someone. In fact, there's Third Circuit precedent. You can do it. The problem for the majority wasn't that there was dry celling going on. It's that there's no evidence that there was a legitimate penological interest after the first 4 days. And the dissent said, no, these conditions are so serious that we have to he ought to at least be able to go forward on his motion for summary judgment on the conditions claim too.
Okay, with that, let's move on to the next case, which comes out of the Eighth Circuit.
Right. So the Eighth Circuit case is Rogers versus Bryant, where two homeless people decided to challenge the current iteration of Arkansas's anti-loitering ban, which actually serves mostly as an anti-begging ban. So one of the plaintiffs in this case, Michael Rogers, is a disabled veteran that uses the money he receives panhandling to support himself. The other, Glenn Dilbeck, is a homeless man that, again, uses the money he receives to support himself and also to contribute to his daughter's medical bills. Both had been jailed and fined and charged under previous iterations of this ban. And under the current ban, both had substantially changed how they went about panhandling. So Michael Rogers had changed the signs that he used and stopped using signs altogether in some cases in order to not draw attention to himself. And Glenn Dilbeck actually claims that he left Arkansas and moved to Tennessee, and because Tennessee had laxer panhandling laws in order to protect himself. So the law at question here really prevents asking for charity or a gift in a manner that is harassing or threatening, that is likely to cause alarm, or that impedes traffic. And the problem is that it singles out asking for charity or gifts. It's a content-based regulation of speech. It doesn't prohibit protesting in such a manner, leafleting, proselytizing. Those are all fine under this law. It's only if you're asking for charity or gift that you're going to run into a problem where you can be fined up to $500 or put in jail for up to 30 days. So the district court in this case granted the two plaintiffs a preliminary injunction, and the judge actually extended the injunction beyond the two plaintiffs and said that Arkansas could not enforce this plainly unconstitutional law against anyone else during the pendency of this case. Arkansas appealed that ruling with a whole host of arguments saying that the plaintiffs didn't even have standing, that the law was perfectly fine and there was nothing wrong with them making this distinction, and that even if the law was unconstitutional, the court should only enjoin them from enforcing it against the two particular plaintiffs. The Eighth Circuit held unanimously both that the plaintiffs were entitled to an injunction and that the law was likely unconstitutional and that they had standing. However, the court differed over whether the injunction should expand to the plaintiffs or whether it should expand to everyone entirely and say that Arkansas just can't enforce this law, period. So two judges agreed that Arkansas couldn't enforce the law at all. One judge dissented, saying that no, we don't have this power to issue what is known as a universal injunction. Now, universal injunction might sound like a new term, but what it really is it's the same thing as a nationwide injunction as far as the overarching controversy is concerned. A universal injunction is simply an injunction which provides relief to non-parties in a non-class action lawsuit. It can be nationwide, and when a universal injunction is issued against the federal government, it usually is nationwide because the federal government exists in a nationwide manner. However, it can be statewide, as it was here, because it was issued against a particular state.
So what's the problem with the state saying, like, we just don't want homeless folks out there harassing motorists and pedestrians? And what was the reasoning?
Right. So the reasoning was that the state provided no actual evidence and no actual facts that people that were homeless and panhandling presented any more danger or any more impediment than protesters, than people leafleting. They provided no evidence. And this is kind of the real case of judicial engagement. Because the two plaintiffs were asserting a right that the court thinks is fundamental, right to free speech, the court actually will look and require the government to give an actual reason and to present actual evidence. If they had been asserting a different right, it may have turned out quite differently.
Jeff?
Sure. So, this case presents two interesting issues. One kind of obvious about the free speech stuff, and then the much less sexy kind of technical thing, which actually really matters to constitutional lawyers, which is about the scope of the relief that a court can grant. So on the front end for the free speech stuff, there's just a huge amount of law on speaking in public, in quintessential public forums like public rights of ways or parks or things like that, and courts trying to balance the rights of people who are, using the public rights of way to get from A to B, not to be accosted, not to be threatened, not to be intimidated. You see this stuff in the abortion context all the time, people protesting outside clinics, but then also the right of people to engage in speech. And, the big problem here is, as Adam pointed out, that really this is aimed at people asking for alms, like a kind of charitable speech that has existed for thousands of years in every culture. Help me out. And courts invariably find that these are First Amendment violations, and cities nevertheless continue to write creative ordinances to try to get rid of this, very traditional, very fundamental form of speech. Now, kind of on the back end, on the scope of the remedy, we run into this all the time at the Institute for Justice, where we will win a case and the government will say, okay, you've demonstrated that this law is unconstitutional as applied to your clients. And admittedly, there are thousands or hundreds of thousands or millions of similarly situated people. Nevertheless, we think this injunction should apply only to you, almost as though they want a judge to say, okay, you can enter an injunction that says the police can't beat your client, but the police can continue to use some kind of method of arresting people that's, found to be unconstitutional with respect to our clients. And it's crazy. If we're going to take our constitutional rights seriously, the remedies have to reach beyond individual cases.
And yet there's a dissent who disagrees.
Right. So the dissent disagreed, and it's kind of hard to tell what the dissent was actually thinking. I think he may not have been as harsh as his dissent seemed. He asked a couple questions during oral arguments that seemed to suggest he may have thought a little bit differently if this was not a preliminary injunction. But at the conclusion of the case, he had a few lines in his dissent all about kind of that Arkansas, or that the court was just assuming that this law was unconstitutional and that Arkansas may come up with evidence, but he seemed quite doubtful of that in other circumstances. And he also agreed with the kind of the characterization of the law as completely unconstitutional, or as plainly unconstitutional. His issue with the scope is kind of this issue that we've seen again and again, that judges don't have the power to issue injunctive relief that protects non-plaintiffs in a non-class action lawsuit. And he was arguing that it wasn't a class action. They weren't even arguing that that they were representing other people at all, that it was just about these two people. What the dissent didn't bring up, and what the majority didn't bring up either, which I thought was quite fascinating, was that they both cited to a case which said that injunctions are to be no more burdensome to the defendant than necessary to provide full relief to the plaintiff or complete relief to the plaintiffs. But they didn't seem to consider what that looked like in kind of practicality and reality. So if the injunction was limited only to these two plaintiffs, are they saying that all the cops and all the police officers in Arkansas must memorize these two panhandlers' faces so as not to arrest them, not to cite them, not to harass them? Or are they saying that, hey, they might get arrested, they might get harassed by the cops because they're out there panhandling, but eventually it'll be figured out that they have an injunction and the cops will kind of just drop the charges? So I think this whole idea of full protection and complete protection is also another interesting way that I think hasn't been well explored and wasn't explored really by the majority or the dissent in this case.
Yeah, and the issue of having like a highly individualized remedy that applies only to the specific plaintiffs in the case sort of raises weird qualified immunity issues, because if you have a court that says the government violated the rights of these two people in this case, one would think that means those are clearly established. And so the government would not want its officials engaging in the exact same behavior with respect to some other citizen to whom that initial injunction doesn't apply, because they could be individually liable for violating now clearly established rights. It seems like we want to have remedies that reach not just the specific plaintiffs, but also similarly situated people. And that makes, public interest law most efficacious because we can maximize the protection of liberty.
Agreed. And I think it's the idea that they should be able to continue enforcing this law. So Arkansas's argument was that, fine, we won't enforce it against these two people, but we want to continue enforcing it against everyone else. It kind of leads to this idea in this kind of theory that the government has a right to enforce unconstitutional laws, and you don't have a right not to have unconstitutional laws enforced against you, and that in order to gain protection, you have to have means and you have to have access to the courts. Now, these two plaintiffs were lucky enough to have another public interest group, the ACLU, represent them, but there are a lot of people that wouldn't have that opportunity. And when you're thinking of people that lack money, so homeless people that are panhandling, how many of them on a regular basis are going to have kind of access to the courtrooms in the first place where they can bring a suit, where they can say, hey, this law is unconstitutional and I am being forced and I'm being jailed or fined because of an unconstitutional law? They're just not going to have that kind of an opportunity.
Okay, well, we're 2 for 2 on judicial engagement cases. Jeff, are we going to make it 3 for 3 today?
I think we're just going to be batting 2 out of 3 today, John.
Okay, let's move on to the last case.
Yeah, the last one is a tough one for judicial engagement and a tough one for constitutional lawyers in Washington State in particular. And this particular case is a decision by the Washington Supreme Court about Seattle's first-in-time law. And this is a law that said that when you put a property for rent on the market, like if it's in an apartment building or something like that, not an owner-occupied type of home, but if you put a typical apartment on the market, you've basically got to take down the names of the people who apply or show up, write them down in order, and the first person who satisfies the objective criteria that you have in your ad, like you're willing to pay $3,000 a month and you're willing to move in on December the 1st, that kind of thing, you have to take the first person who comes along. Now, Seattle, kind of the preamble to this law is that it's designed to enhance affordability, equity, and inclusiveness. In some ways, the law represents an effort to wrestle with the basic contradiction of housing in America, which is that everybody says they want affordable housing, but at the same time, everybody wants housing prices to be galloping ever upward so that they become investments. And so one of the ways Seattle is wrestling with this, as well as other issues associated with housing discrimination, is to try to do this law. So the first-in-time law was challenged under the Washington state constitution, under the Takings Clause, as well as the Due Process Clause, a substantive due process claim. And the theory was that, okay, we recognize that federal constitutional law provides, comparatively little protection under the Takings Clause and under the substantive due process doctrine. But Washington state for decades has developed an independent constitutional law under its own state provision, and that the state constitution provides more robust protection. And this effort is part of, particularly in property law, what a number of public interest attorneys are doing across the country, which is after the Supreme Court, for example, in the Kelo case in 2005, said there are essentially no federal constitutional limits on the use of the takings power, that they, people like IJ, we're going into court and saying, look, we're suing under the state constitution, under the corresponding state takings clause, and urging courts, such as the Ohio Supreme Court, for example, the year after Kelo, which rejected Kelo and said that, we have different constitutional language, we have a different constitutional history, and we have different case law. And so we provide better, stronger, richer protections for property rights than the federal counterpart. So this was the theory in Washington. They were going to harness that different language, different constitutional history and tradition. And the Washington Supreme Court absolutely slammed on the brakes and said, no. Admittedly, we have looks like we've had an independent case law over the years. And I can see why you're confused, because we have dozens of cases suggesting that we do have a distinct case law. But it turns out that all we were doing in all of those cases is attempting to discern the federal standard. And we'll make it clear today that for our takings doctrine and substantive due process as it relates to property rights, it is exactly the same as the federal doctrine. So and they overruled by name, I think, dozens of Washington cases. This is probably the most sweeping judicial opinion of any kind, state or federal, that I have ever read, where there is just a wholesale repudiation of generations of independent constitutional doctrine. And so people in Washington state woke up with far fewer property rights protections than they had the day before.
Adam, tell me about the appendix that the Washington Supreme Court released.
So the Washington Supreme Court overturned so many cases, and so many cases just on the due process argument, that they had to attach an appendix to list all the different cases that seemed to suggest that they had a different test under the Due Process Clause in regards to property rights than the federal government did, and said, no, you can't rely on any of these cases anymore because we don't actually have an independent constitution as far as due process goes, which is just shocking and a little bit surprising. The Washington Constitution was written over a century after the U.S. Constitution, and they put all these provisions in there. They put all these independent provisions in there. If the drafters of that Constitution simply wanted it to go along with whatever the federal Constitution was, whatever the federal constitutional law was, they could have simply said that in the Constitution. But I think the fact that they wrote these rights down has to mean something, and especially when you consider the fact that it was written in a totally different context, a totally different time, by totally different people. Just to say that, well, we've somewhat interpreted it differently for quite a long time, but we really didn't mean to, and that was kind of accidental. So we're just going to say whatever the federal government says. As far as due process and takings clause and the takings clause goes, what's really interesting is they actually have in other cases said that their constitution provides more protection than the federal constitution in terms of search and seizure. So I think it'll be very interesting to see if that continues, if they continue to think that their search and seizure provision provides more protection than the federal constitution, or if there's just another case that's going to come out in a year or two that's just going to say, sorry, this is just the same as the federal constitution as well.
Right. And really, this is what the Washington Supreme Court did here, is just jump on the elevator and find the button that went to the lowest floor. Because the whole theory is that the federal constitution provides the minimum floor of rights across the country. States can't declare that you have fewer rights than in the federal Constitution. And Washington said, oh, you thought you were living in the penthouse. Actually, you're in the basement suite next to the superintendent and the clanging furnace.
And this is exactly one of those cases where the courts just defer to the government. So in this case, they deferred to the Seattle City Council and said, I'm sure you must have had a good reason for putting in these requirements. You don't have to tell us. But the plaintiffs, if they want to win this lawsuit, have to negate every possible reason that you could have had for enacting this law. So the plaintiffs kind of have a near impossible situation where they have to prove a negative, which is quite challenging. It's certainly possible to be done, but...
And it's exactly at this moment that judicial engagement matters because, the formulaic description of rational basis review is any conceivable justification, which could start at aardvark and end at zygote. Nobody can do that as a practical matter. So you need judges in the cases to actually say, look, let's look at the 3 or 4 most plausible justifications for this, the ones that actually could have motivated the legislature. And then your burden really isn't every conceivable one, but it's this small set of plausible ones. Bring forward evidence. You can prove that those justifications are insufficient constitutionally, and you should be able to win. Now, that is true under federal law, and so it should still be true under Washington state law. But, one could understand a lawyer now approaching the Washington Supreme Court with some trepidation that what the overall impression that this opinion is supposed to leave is we are essentially out of the business of enforcing constitutional property rights under the Washington Supreme Court, and it may take a while. We may need to wait for close to near turnover of the court before lawyers will have an opportunity to really dig back in against this decision.
Adam, the court really patted itself on the back here and said that they were, using great restraint in quotes. What are they talking about?
Right. So what the court's talking about here is this idea that they shouldn't question the policy enacted by a legislative body here, the Seattle City Council. But what they're really doing actually is they're in their desire to be restrained and not to overturn laws unnecessarily. They're overturning decades of their own precedent that actually says that their constitution, their own state constitution, matters and should be interpreted independently than the federal constitution.
Abdication most foul. Okay, that concludes the show. Thanks for listening. And so until next time, this is John Ross bugging you to get engaged.